Welcome to The Explainer. Today we're stepping into a fiercely competitive arena. The world of modern commerce is essentially a battlefield. It's a place where your business identity is literally everything. Think about it for a second. The name of your company, the logo you use, the specific colors on your packaging, these aren't just mere decorations. They are your most valuable assets. And out there in the market, there is always someone looking to steal them. So today, we're demystifying Indian trademark law to understand exactly how businesses arm themselves for this very battle.
Let me ask you something. Have you ever been tricked into buying a fake brand? Maybe you grabbed a quick coffee or bought a pair of shoes, only to look really closely later and realize the logo was just slightly off. It's an incredibly infuriating feeling, isn't it? You basically feel cheated out of your hard-earned money. Now, flip it around. Imagine being the business owner whose hard-earned reputation is being hijacked by that fake. It's a massive problem, but thankfully, the law has mechanisms to let you fight back.
Okay, let's dive into this. To understand how brands protect their territory, here is our roadmap for today. First, the power of a trademark. Second, the threat of deceptive similarity. Third, landmark trademark battles. Fourth, the difference between passing off and infringement. And finally, legal remedies and reliefs.
Starting with Section 1, the power of a trademark. If the market is a battlefield, well, a trademark is a brand's armor. It's the exclusive mark used to distinguish a specific good or service from all the millions of others out there. And the fight to build this armor in India, it isn't a new one. India's trademark law actually dates all the way back to 1860. By 1879, Bombay mill owners and the Bombay Chamber of Commerce were actively pushing the state of Bombay for a dedicated trademark protection law. This evolved over the decades, leading to the first official Trademarks Act in 1940, which was later replaced in 1958. Finally, to comply with international TRIPS obligations under the World Trade Organization, India enacted the powerful Trademarks Act of 1999, and that is the legal foundation we operate on today.
So what exactly does this legal armor do for you? Under modern business conditions, a trademark performs four vital functions. First, it identifies a good or service and its origin. It basically tells you exactly who made it. Second, it guarantees an unchanged quality, assuring consumers they're getting exactly what they expect. Third, it acts like a silent salesman, advertising the goods. And fourth, it creates a lasting image or persona for the product in the consumer's mind. It takes this abstract idea of goodwill and turns it into a highly practical business tool.
And perhaps the most surprising aspect of all this is how accessible this legal armor actually is. According to Invest India, the baseline government fee to file a brand new trademark application electronically is just 4,000 Indian rupees. For what is a relatively small investment, a business can completely secure the exclusive right to use their mark and stop shady traders from unlawfully hijacking their identity.
Moving on to Section 2, the threat of deceptive similarity. And this brilliantly illustrates the central conflict for brands, deceptive similarity. It's when copycats attempt to steal visual or phonetic identity to just siphon off customers. I mean, look at these real-world examples. You've got the famous leaping cat of Puma side by side with a logo that says Coma, or the iconic green circular mermaid logo of Starbucks copied almost exactly by a brand calling itself Starbucks. This is definitely not an accident. This is blatant mimicry designed entirely to deceive the public and ride on the coattails of an established brand's hard work.
To fight this, the law formalizes the rules of engagement. Under Section 2H of the Trademarks Act of 1999, a mark is deemed deceptively similar if it so nearly resembles another existing mark that is likely to deceive or cause confusion in the minds of consumers. Basically, visually or phonetically, if it's too close for comfort, it's illegal.
But how do courts actually prove this in real life? They rely on criteria established by the Supreme Court of India in a landmark pharmaceutical case, Cadila Healthcare Limited versus Cadila Pharmaceutical Limited. The plaintiff sold a medicine called Falsigo, and the defendant started selling a similar medicine named Falsitab. The Supreme Court outlined specific testing criteria here, including the degree of resemblance, the nature of the goods, and the level of care a purchaser exercises. Crucially, the court noted that trademark confusion isn't just about mistakenly buying the wrong cup of coffee. In the medical field, confusing Falsigo and Falsitab could quite literally lead to dangerous medical negligence.
Let's move to Section 3 and see how this builds into some landmark trademark battles.
Let's see how these courtroom showdowns actually play out in the real world, where the theory of deceptive similarity is put to the ultimate test. Take the case of Lakme versus Like-Me. The plaintiff was the well-known seller of cosmetics under the registered brand Lakme. The defendant started selling a very similar class of cosmetic products under the name Like-Me. The Delhi High Court stepped in and granted an injunction against the defendant. Why? Because the names are phonetically so similar there was a striking resemblance that would very likely deceive consumers into buying the wrong makeup.
But you know, the law is full of nuance. Consider the battle between Picnic, spelled with K's, a brand selling chips and wafers, and Picnic, spelled with C's, a brand selling chocolates. The trial court initially ruled they were deceptively similar, but in a pretty surprising twist, the High Court reversed the decision and the Supreme Court actually upheld it. They ruled these marks were not deceptively similar because they were entirely different in visual appearance and word composition. Here's another genuinely fascinating one. The plaintiff owned the trademark for Officer's Choice alcoholic beverages. The defendant sold alcoholic beverages under the trademark Fauji. So the plaintiff sued, arguing that the word Fauji translates to military officer in Hindi, making it deceptively similar in concept. So let me ask you, is Fauji the same as Officer's Choice? Well, the court didn't think so. They dismissed the infringement suit entirely, stating that conceptually translating a word doesn't automatically create deceptive similarity under the law.
Section 4. Passing off versus infringement.
When a business gets copied, they have specific legal weapons depending on if their mark is actually registered or not. If a brand hasn't registered its trademark but has a really strong reputation, they launch what's called a passing off action. This relies on the classical trinity. Step 1, the brand must prove they have established goodwill in the market. Step 2, they must prove misrepresentation, meaning the defendant intentionally deceived the public. And Step 3, they must prove actual damage, or at least the likelihood of damage to their business.
Now, what's really interesting about this slide is how stark the differences between these two weapons are. Passing off is a common law principle available for unregistered trademarks, but it is notoriously hard to prove because you must show actual confusion in the public's mind. Infringement, however, is a statutory right under the 1999 Act, strictly for registered trademarks. It is a much sharper weapon. To win an infringement suit, merely proving the similarity in the trademark is often enough. You don't necessarily have to prove the public was actually confused.
But honestly, whether it's passing off or infringement, the entire legal framework rests on one beautifully simple, foundational principle. As stated in the sources, a man may not sell his own goods under the pretense that they are the goods of another man. This single quote just perfectly embodies the absolute spirit of intellectual property protection.
Finally, Section 5. Legal remedies and reliefs.
So, when a court decides a copycat has crossed the line, what are the tangible consequences? Under Section 135 of the Trademarks Act, the punishments are both severe and incredibly practical. The court can grant an injunction to immediately stop the copycat from selling. They can award financial damages or force the copycat to hand over all the profits they made. They can even restrain the defendant from disposing of their assets to ensure the plaintiff actually gets paid. But perhaps the most dramatic relief is the delivery up order. The court can literally mandate that the infringing labels, goods, and marks be physically handed over for complete destruction or erasure.
So, the crucial point is this. Trademark law isn't just a bunch of dusty regulations in a textbook. It is the active defense of creativity, quality, and consumer trust, and it directly impacts absolutely everything you consume. Take a second and look around your room right now. How many of the so-called original brands you own are actually riding on the goodwill of someone else's hard work? It is a brand battlefield out there, and now you know exactly how the rules of engagement work. Thanks for joining this explainer, and we'll see you in the next one.